Good afternoon and welcome all to the second session in our bite-sized webinar series. Thank you all for joining us this lunchtime. By way of an introduction, my name is Rebecca Jones and I'm a solicitor in our medical negligence team at Irwin Mitchell, and I'm pleased to be joined today by my colleagues Rachel Smurthwaite and Kirsty Stewart from our public law team, who will be discussing the topic of preparing you and your child for their transition to adulthood, including how this will affect medical care and services, their transition from school to higher education, and how EHCPs, which we spoke about in last week's session, are impacted, and also gaining independence as an adult. So before we start, just a couple of housekeeping points. You should all have a box at the right side of your screen which gives you the option of ask a question. If you do have any questions which come up during the session, please do submit your questions via this box and we'll get to as many as we can at the end of the session. When submitting your question, please include your name and email address if you can, so then if we can't get to your question today, we can respond to you directly after the session. We've also received a number of questions which have been submitted in advance, so thank you very much for everybody who sent those in. Today's event will be recorded and the recording will be sent out afterwards. So if you do want to rewatch this again, then there will be opportunity to do so. And finally, towards the end of the session, we'll be posting a feedback link, and we would really appreciate it if you could just take a couple of minutes to give us some feedback on today's session. So to get things started, I will hand over to my colleagues Rachel and Kirsty.
Thanks, Rebecca. Welcome everybody to this webinar this morning. Thanks for coming along. My name is Rachel Smurthwaite and I am a solicitor who specialises in education law here at Irwin Mitchell. I've been practising in this area for about 9 years now. I represent parents and young people who wish to challenge decisions relating to their education. My main focus is on securing provision for children and young people with SEN, but I also engage in work relating to school admissions, school exclusions, disability discrimination, home to school transport, bullying and judicial reviews on subjects such as school closures, SEN budget cuts, etc. I'm co-hosting this webinar today with my colleague Kirsty Stewart, who I will pass you on to now to introduce herself.
Hiya, thank you. My name is Kirsty Stewart. I'm a solicitor in the Public Law and Human Rights Department at Irwin Mitchell. I represent a range of individuals who wish to challenge decisions about either themselves or their families. And this is for people who both lack capacity and also have capacity to make relevant decisions. So I work within several spheres, ranging from court of protection, community care, judicial review and human rights. My background is in mental health law, and because of that I lead in the firm on cases involving those with learning disabilities or those who are autistic in assessment and treatment mental health inpatient units. And I'm also a parent carer myself, so I do really understand some of these more tricky issues, and although I'm not at the point of transition to adulthood yet, I do get how much of a fight it can be for us parents in this scenario. Our contact details are there, and also I've shared some useful links in the chat bar which will be relevant for all of the areas that we're going to cover today. You should be able to see those now. So I'll pass back to Rachel now, who's going to start on the education side.
Thanks, Kirsty. Okay, so to begin with, I'm going to briefly look at educational law duties during transition. Next slide, please. So the main pieces of legislation and statutory guidance relating to SEN are the Children and Families Act 2014, the Special Educational Needs and Disability Regulations 2014, the SEN Code of Practice January 2015, and case law. So local authorities have a general duty to secure provision which meets a child or young person's special educational needs. It should be noted, however, that in the case of RV Surrey County Council, it was determined that there is no obligation on local authorities to provide a child with the best possible outcomes or to educate them to their maximum potential, i.e. the local authority only has to educate them to achievable outcomes or potential based on their age, ability, aptitude and their SEN. In the case of AV Hertfordshire County Council, it was determined that local authorities must provide what is reasonable. It should be noted that reasonably required is not defined in the Children and Families Act, and so what is reasonably required will be determined on the facts of each particular case. Next slide, please. Moving on to general transition to adulthood duties then. Paragraph 6.1 of the SEN Code of Practice cites the rights of children and young people to have an education which meets their needs, fulfills their potential and promotes high standards, so that they are able to achieve their best, become confident individuals and make a successful transition to employment, further or higher education or training. Not all children and young people with SEN will gain qualifications throughout their educational journey, and this isn't in fact necessary. The case of Buckinghamshire County Council v SJ showed this most clearly when the local authority carried out an EHC needs assessment for a 20-year-old who was functioning at preschool level, but they declined to issue an EHCP following the assessment. The case identified that although educational achievements would be small for SJ, an EHCP nonetheless should be issued because those achievements, however small, would be invaluable in SJ's life. Next slide, please. When writing or reviewing EHCPs, the SEN Code of Practice states at paragraph 9.61 that they should be looking forward, i.e. anticipating, planning and commissioning for important transition points in a child or young person's life, including planning and preparing for transition to adulthood. Furthermore, it is a requirement in accordance with Regulation 12.3 of the SEND regulations that where a child or young person is in Year 9 or above, their EHCP must include healthcare and social care provision, where appropriate, to assist them with their preparation for adulthood and independent living. Next slide, please. Moving on to outcomes then. EHCPs, as you may know, have outcomes specified in Section E. Those outcomes must be focused on education and training, health and social care that will enable children and young people to progress in their learning and as they get older to be well prepared for adulthood. Paragraphs 9.64 to 9.69 of the SEN Code of Practice identify the various types of outcomes, i.e. they can be social or emotional, as well as formal and more accredited outcomes. They should state what the child or young person needs to achieve by the end of a phase or stage of education to enable them to successfully progress to the next stage. They should also set out the benefit or the difference made as a result of the support, and from Year 9 onwards, they should show how the outcomes will enable the young person to make progress towards their aspirations. Next slide, please. Moving on to ceasing to maintain EHCPs then. In accordance with Section 45(1) of the Children and Families Act, local authorities can only cease to maintain an EHCP where it is no longer responsible for the child or young person, or it is no longer necessary for them to have an EHCP. In addition, paragraphs 9.152 to 9.153 of the SEN Code of Practice state that local authorities must not cease to maintain an EHCP just because a young person is aged 19 or over. Local authorities must consider whether the educational or training outcomes specified in the plan have been achieved in deciding whether special educational provision is no longer required. It should be noted that where a young person is close to finishing their educational training, their final annual review of their plan should be used to agree the support needed to help them engage with services after they turn 19. Next slide. A recent case in relation to a cease to maintain is the case of B&M v Cheshire East Council. I have included details on this slide for you to read at your leisure due to the time limits today, but essentially the court determined that achievement of outcomes does not automatically mean that an EHCP should be ceased. Next slide, please. Finally, if the local authority ceases to maintain the EHCP and the young person or family disagrees, they can appeal to the Special Educational Needs and Disability Tribunal. Section 45(4)(b) of the Children and Families Act states that whilst any appeal is ongoing, local authorities must continue to maintain the EHCP, including placement and provision, until the outcome of that appeal is known. I'm now going to pass to my colleague Kirsty, who will talk to you about health and welfare deputyships. Thank you.
Thanks, Rachel. So I'm going to move on to the topic of health and welfare deputyship, which I know that some people have sent in some pre-questions about, so hopefully this will cover a lot of the topics. If there are other questions that you have around this, do pop them in the Q&A and I'll address those at the end. Next slide, please. So the jurisdiction that we're talking about today is the Court of Protection in relation to this. The role of the Court of Protection is to step into the shoes of individuals who lack capacity to make specific decisions. This means that the court cannot become involved with those who have been assessed as having capacity to make specific decisions, or must step away if during those proceedings they're assessed as being able to make the relevant decision. The court is divided into two distinct areas, that is the provisions in relation to property and financial affairs and also health and welfare. I'm only going to be covering the issue of health and welfare, as this is my expertise. We do have experts who deal with financial deputyship, and I know that this is also being covered in one of the later bite-sized sessions, so it may well be worth linking in with that if you need further information on that front. Also, to be clear, when I'm referring to deputies, you may have also heard information about powers of attorney. And I just wanted to confirm that the difference between them is that a person with capacity to make decisions can appoint an attorney to make future decisions in the event that they then may lack capacity, whereas a deputy is someone who's appointed once and only if a person lacks capacity to make that relevant decision. So if you're talking about young people who you think already lack capacity, then that's more deputyship than it would be power of attorney. The Court of Protection has various powers which you may well have come across, and which includes the ability to appoint a deputy to make ongoing decisions in respect of either finances or welfare, or to make one-off decisions. Further, and if appropriate to do so, the court can also remove deputies or attorneys, and they are often asked to resolve disputes which may exist. Once a deputy is appointed by the court, they will become the primary decision maker and will have to consider what is in that person's best interests. So prior to this, or without deputyship being in place, the process involves holding a best interest meeting with all professionals and family and making a joint decision about what may be in the person's best interests. And then if a dispute did exist at that point, then asking the Court of Protection to step in and resolve it. Could you go to the next slide, please? One thing to note is that the existence of welfare deputies is far more rare than financial deputies. In terms of stats, there are about 15,000 applications granted for financial deputyships a year, and this is versus 1,000 welfare deputies. The reason for this appears to be that the law is against making them, basically. So even just the wording in section 16, which is the relevant part of the Mental Capacity Act, which actually talks about them, there's a preference on the court decision making these individual decisions versus appointing a deputy. And the case law, I would say, on this topic is actually quite mixed. When the court does grant these, they grant the authority to the deputy to make care, health and welfare decisions on behalf of the person who lacks capacity. So, for example, this may be what sort of treatment they have, making decisions about, for example, a care home that the person goes to, and the type of care that they receive. I think of a lot of people do consider that because they're next of kin for their loved ones that this is enough. That isn't the case in English law. Families will be asked for their views, but that doesn't necessarily need to be followed to the letter by health professionals if deputyship wasn't in place. It is for the court to decide on whether to grant a deputyship, but also it's for the court to decide who that person is. The code of practice talks about somebody who is reliable, trustworthy, and has an appropriate level of skill and competence to carry out the necessary skills. This would certainly relate to a lot of parent carers who, in my view, dedicate their lives to their child and their needs, who then in turn turns into an adult with needs. Based on the criteria, it's very clear to see why a parent carer would then be able to fulfil that role. You become an expert at your own child's condition, and you have to really consider your child in the round, and not just from one clinician or health professional's perspective, and that's something you will have done all of their life likely. The court considers that deputies for welfare decisions will only be required in the most difficult cases where important and necessary decisions cannot be carried out without the court's authority, or there is no other way of settling the matter in the best interest of the person who lacks capacity to make those particular decisions. So in terms of who can become a deputy, this can be a range of people. The Code of Practice recognises the role of family members. This doesn't necessarily mean it has to be parents though, so long as they meet the criteria. And I know that the Code of Practice also talks about professionals who could become a deputy. So they give the example of the Director of Adult Social Services. So that could be appropriate if there's concerns and disputes within the family, or there's a need for a dispute, but there's no one who's actually identified as being appropriate. Could you go to the next slide, please? So in terms of the question of what is the correct approach to determining whether a welfare deputy should be appointed, this was actually explored in a case concerning 3 different applications before Mr. Justice Hayden in 2019. All these individuals were young people ranging from ages 20 to 24 and having varying but high care needs. This actually was a crowd-funded case looked after by some of our colleagues in the London office, and really sought to clarify the law and criteria around the appointment of deputies. In each one of the cases, the proposed deputy was a family member. All 3 had care packages and complex needs, which was felt to be appropriate to warrant the use for health and welfare deputy. I have included the link there for the judgment, so if you want to go and have a read a bit more about this, then by all means do. The court recognised in this case that parents do find the transition to adulthood difficult. The team of professionals changes from children's to adult services, and the role you as a parent have changes when the person attains the age of adulthood, regardless of their level of need or perceived or assessed, often termed mental age. The impetus of parents to explore this route is often to help protect their children in the way that they always have, but the court also recognises that things change in terms of the role of those children who have capacity to make relevant decisions when they turn 18, and they need to try and be consistent with that approach. So I have actually spoken to some of my colleagues to see where this case actually stands. And it's quite interesting. So one of the cases has been granted now a welfare deputyship. One of them has ceased to be continued, and the other one, they're actually exploring whether the young person actually has capacity at this time and therefore can make a power of attorney for future decisions. So it's definitely kind of a watch this space kind of affair. And what I would say is that the Code of Practice and also the current case law is quite mixed in this area, which I think really isn't helpful when parents are kind of considering whether this is appropriate or not. Could you go on to the next slide, please? So I've set out the process there of making an application for welfare deputyship. The process can take around 6 months or more. The court forms are available online if you want to have a look, and I've just listed them there. It's the ones that have COP and then the number afterwards if you wanted to give that a Google. They include forms to outline what decisions you're asking the court to make, evidence to show why you need that, and also evidence in relation to how the person has been assessed as lacking capacity to make the decisions of themselves. There is a court fee which is payable for the application, and the forms also indicate what other forms you may need to file with them and accompany them, and also helpful notes to follow as well. We do recommend that you provide really detailed information with your application to increase the chances of it being successful, and can also help and advise you at each stage of this. But this is what it would look like if you were to set it out. So just to note as well, this isn't covered by legal aid in terms of funding, but what we've had real positive success with more recently is crowdfunding for these applications, with one family in fact raising the entire legal fees for an application in less than 24 hours. So that was for us to help to support to make that application, as well as the court fee, which is absolutely fantastic. And like I said, we can help you at each stage of the process, and also for setting up your page if crowdfunding was something that you wanted to explore. So I'm now going to pass back to Rachel, who's going to be talking about NHS continuing healthcare.
Thanks, Kirsty. So yeah, first of all, we're going to look at continuing healthcare for those under the age of 18. Thank you. So the local clinical commissioning group, CCG, is responsible for continuing healthcare in adults and children. A continuing care package will be required when a child or young person has needs arising from disability, accident or illness that cannot be met by existing universal or specialist services alone. This means over and above the services offered by the GP or hospital services. It should be noted that just because a child qualifies for CHC, it doesn't mean as an adult you will. There are 3 phases to the CHC process. The first is assessment. A child or young person will be referred with a possible continuing healthcare need to the CCG. The health assessor will then undertake an assessment which includes the preferences of the child and family, a holistic assessment of need, reports from the multidisciplinary team, and the completion of a document called a decision support tool, which will rank needs in several categories. The second is decision making. The MDT forum considers the recommendation of the assessor and decides if the child or young person has a continuing care need. The third phase is arrangement of provision by commissioning a package of care following development of the costed care package and ongoing reassessment. Where a child or young person or their family is eligible for continuing care, requests a personal health budget, the responsible CCG must arrange for the provision of care by means of a personal health budget. This can be achieved in one of several ways. Firstly, a direct payment made to the young person or their family, or the agreement of a notional budget to be spent by the CCG following discussions with the child or young person and their family or other representative as to how best to secure the provision they need. Or finally, the transfer of a real budget to a person or organisation which applies the money in a way agreed between the CCG and the child or young person and their family or other representative. Next slide, please. The transitions to adulthood. Future entitlement to adult NHS continuing healthcare should be clarified as early as possible in the transition planning process, especially if the young person's needs are likely to remain at a similar level until adulthood. And this should be accomplished by undertaking an initial screening for NHS continuing healthcare at a suitable point when aged between 16 and 17. At 14 years of age, the young person should be brought to the attention of the CCG as likely to need an assessment for NHS continuing healthcare. At 16 to 17 years of age, there should be a formal referral to the adult NHS continuing healthcare team at the relevant CCG, and screening for NHS continuing healthcare should be undertaken using the adult screening tool and an agreement in principle that the young person has a primary health need and is therefore likely to need NHS continuing healthcare. At 18 years of age, full transition to adult NHS continuing healthcare or to universal and specialist healthcare services should have been made, except in instances where this is not appropriate. Next slide, please. So moving on to NHS continuing healthcare for over 18s. NHS continuing healthcare is a package of care for adults aged 18 or over, which is arranged and funded solely by the NHS. In order to receive NHS CHC funding, individuals have to be assessed by CCGs according to a legally prescribed decision-making process to determine whether the individual has a primary health need. An individual has a primary health need if, having taken into account all of their needs, following completion of the DST, it can be said that the main aspect or majority part of the care they require is focused on addressing and/or preventing health needs. Having a primary health need is not about the reason why an individual requires care or support, nor is it based on their diagnosis. It's about the level and type of their overall actual day-to-day care needs taken in their totality. The screening tool for NHS continuing healthcare is called the checklist tool. It has 11 care domains which are broken down into stages, and the outcome depends on the number of ABCs the person has. The checklist can be completed by a variety of health and social care practitioners who have been trained in its use. This could include, for example, registered nurses employed by the NHS, GPs, or other clinicians or local authority staff such as social workers, care managers, or social care assistants. A negative checklist means the individual does not require a full assessment of eligibility and they are not eligible for NHS continuing healthcare. On the other hand, a positive checklist means that the individual does require a full assessment of eligibility for NHS continuing healthcare. It doesn't necessarily mean the individual is eligible for NHS continuing healthcare though. Once an individual has been referred for a full assessment of eligibility for NHS continuing healthcare, following use of the checklist, or if a checklist is not used in an individual case following direct referral for full consideration, then a multidisciplinary team must assess whether the individual has a primary health need using the DST. The tool provides practitioners with a method of bringing together and recording the various needs in 12 care domains, or generic areas of need. Each domain is broken down into a number of levels. The levels represent a hierarchy from the lowest to the highest possible level of need and support required, such that whatever the extent of the need within a given domain, it should be possible to locate this within the descriptors provided. The categories are priority, severe, high, moderate, low, and no need. A clear recommendation of the eligibility for NHS continuing healthcare would be expected if a priority level of need was present in any of the 4 domains, which are breathing, behaviour, drug therapies and medication, and altered states of consciousness, or a total of 2 or more incidences of severe level of need if identified in any of the care domains. Where a child or young person is found not to have a need for continuing care, a clear written explanation of the rationale for the decision should be provided to the child or young person and their family following verbal notification. CCGs must have complaints procedures in place to respond promptly to any request to review disagreements voiced by the child or young person or their family or carer about any aspect of the continuing care process. If an individual has been screened out following completion of the checklist, they may ask the CCG to reconsider the checklist outcome. The CCG should give this request due consideration, taking account of all the information available and/or including additional information from the individual or carer, though there is no obligation for the CCG to undertake a further checklist. A clear and written response should be given, including the individuals and, where appropriate, their representative rights under the NHS complaints procedure if they remain dissatisfied with the position. Where an MDT recommends an individual is not eligible for NHS continuing healthcare, a clear rationale must still be provided. If an MDT is unable to reach agreement on the recommendation, this should be clearly recorded. Where an individual and/or their representative expresses concern about any aspect of the MDT or DST process, the CCG coordinator should discuss this matter with them and seek to resolve their concerns. Where the concerns remain unresolved, these should be noted within the DST so that they can be brought to the attention of the CCG making the final decision. If you have no joy, then you can seek support from Beacon, an organisation which helps individuals with free advice for up to 90 minutes with CHC related issues. The alternative is to seek legal advice for these issues. Again, you can search for solicitors on the Law Society website. This work can be covered by means-tested legal help. I'm now going to pass you back to Kirsty, who will talk to you about the Court of Protection. Thank you.
Thank you. So the Court of Protection General can consider a person's ability to make decisions in lots of areas, and really this can range from where they live, who they have contact with, right through to medical treatment and whether that person has capacity to marry, for example. It is time and decision specific, so each decision has different relevant information which a person has to be able to understand, retain, use or weigh, and then communicate as part of the capacity assessment for that area. You may have heard of DOLS, or deprivation of liberty, and the wording of this I think makes us instantly feel quite defensive, but actually what it does is it can provide our loved ones with the right legal safeguards. The Court of Protection is only applicable if the person has been assessed as not having capacity to make decisions about their care and support, if we're talking about DOLS. So the DOLS system came into force in 2009 to protect the rights of those who were deprived of liberty and required care and treatment. They're due to be replaced by the Liberty Protection Safeguards, which I won't touch on necessarily here as they're not currently in place. But it is something that is in the pipeline. It's been delayed several times, as you may well be aware, but hopefully this year they will be coming in a bit more, and we'll know maybe when they're actually going to come into force. What you need to consider is whether in whatever setting a person is in, that they meet what is termed to be the acid test in relation to deciding if a person is deprived of their liberty. This was established in a case known as Cheshire West and asks two really important questions. So is the person under continuous supervision and control? And secondly, is the person free to leave? And the focus is not on the person's physical ability or desire to leave, but what the carers would do if they did leave. So for a person to be deprived of liberty, they must fulfil both criteria. And if this is the case and the person is in a place like a family home or their own property with a tenancy agreement and carers, which is non-CQC registered, a court of protection application must be made to authorise that deprivation of liberty. The local authority should be making that application, but it can also be made by families on behalf of a person who's being deprived of their liberty. During this process, the care plan will also be scrutinised so that the court can ensure that the person's restrictions are in their best interests and are also the least restrictive to meet their assessed needs. So the person is entitled to legal aid to be represented as our family members separately. It is a means tested legal aid application, and so it is dependent on the person's capital and income. Most firms who specialise in court of protection can tell you quite quickly if you qualify, and there's also a legal aid calculator online. But just to say though as well, the family members don't need representation or legal representation, and the application, if everyone agrees, can be done without an attended hearing. Next slide, please. I have just listed there some potential conflicts which could occur in relation to court of protection, which you may or may not come across. If a deprivation is unauthorised, so for example, I have a case at the moment where this is a situation, and actually has been the case since 2012, the local authority have failed to make an application for deprivation of liberty to the court of protection, and so there is also a potential damages claim, as this is an unlawful breach of the person's deprivation of liberty. So that could well be something which you may come across. The court will authorise a deprivation of liberty for an appropriate care package. So it may be that as part of the proceedings, the care plan is considered alongside any restraint plan, medication, etc. And again, when I get involved, I think some parents can think this is a message somehow that they are not coping, or that they feel as though they're being criticised for something that they're not doing, and it's not at all about that. I often see that local authorities can expect so much of parents, and we actually give it, but it's actually not appropriate, or it's too much, and that needs to be supported and recognised. Also, if P, so the person who lacks capacity to make decisions for themselves, is objecting to that current placement or a particular part of their care plan, which isn't suitable, then the court can explore alternative options to meet that person's needs. Finally, there may be restrictions which are unnecessary or in fact unlawful, such as the restriction of social media or contact with others or the use of contraception. Just because a person does not object to that, it doesn't mean that it does not need to be authorised. So if there are restrictions that cause you any concern, I think the first thing is definitely just to ask the question. Ask for an up-to-date capacity assessment around that particular decision. And then if you do have any further concerns, then obviously do consult a solicitor and see if that's something that needs to be challenged. The court authorised deprivation of liberties will also be reviewed yearly. But if there are issues in between that, you can either raise them on behalf of the person or make an application to the court yourselves if you have concerns. Next slide, please. So I do appreciate that this was a whistle-stop tour of some of the really important issues that you will be coming across in terms of the transition into adulthood. I think what we've really tried to do is just incorporate some of the things that you may well come across, and also some of the questions that people have asked in advance. Like I said, I have put the relevant links to the chat bar, links in the chat bar, which will be helpful. So that will hopefully cover also some of the things if you wanted to look into it in more detail. We've also got lots of really helpful fact sheets and precedent letters on all sorts of different aspects, which you can access and use yourselves if you wanted to explore this further. So I think we're now going to go on to our Q&A. But also just to say there are some more sessions in terms of the bite-sized webinars, and I know some people did ask about financial deputyships, and that is a whole session on itself in a couple of weeks there. Oh, there we go, outline there for you. So so I hope that's also helpful. So shall we go to the Q&A then?
Rebecca, you're on mute.
Sorry, thank you, Rachel and Kirsty. That was really informative and a really important topic to discuss, I think, because there's obviously a lot of change which happens with the transition to adulthood. And I know from our clients that there can be lots of questions and uncertainties around this time as well, particularly when the child has additional needs. So we've had a couple of questions in through the Q&A box, so thank you everybody for sending those in. We'll just go through a couple now, we've still got some time. Rachel, I think this might be one for you. If there is a gap in educational training, can you ask for the EHCP to continue?
Yeah, education, health and care plans can run up to the age of 25. That was the whole point of the change in the legislation from statements to EHCPs. And if it can be shown that your young person requires additional time in education to achieve outcomes which they may have otherwise missed out on, then that is a reason that you can seek to have their EHCP extended up until they meet those outcomes, or up until the age of 25. I think I covered in the cease to maintain slides that local authorities shouldn't just be ceasing to maintain EHCPs at age 19. They do need to look at the wider picture and see what additional outcomes that young person can achieve, and if that means taking them up to the age of 25, then you know an EHCP can still do that.
Thank you, and sort of following on from that, Rachel, another one for you, I think. We've had a question from somebody who's had ongoing problems with their son's occupational therapy input, which was being left out due to the transition from leaving school to going to college. Is there anything that they can do to challenge this post the age of 18?
Okay, so when you've got an EHCP, the child or young person will always have an annual review. So following the annual review where they transitioned from mandatory schooling to college schooling, if any provision had been removed, then you would have had the right to have challenged that decision either through mediation or through an appeal to the SEND tribunal. So if you haven't done that and you're now at least 2 months post annual review, you're no longer going to have a right to mediate or challenge that decision. And what I would suggest you do is that if the lack of that provision is having such an impact on your child being able to access their education, then you seek what we call an interim review, where you say to the local authority, young person's needs are not being met because of X, Y, and Z. We require an urgent annual review because otherwise this is going to happen. This is the impact it's having upon my child or young person. And then that sort of brings into play the whole annual review cycle again. And if they still, following the annual review, decide not to include any provision or take even more provision away, then again you have that right to challenge. But you must always seek to challenge that within a 2-month period, because if you don't, you lose that right and you then have to wait until the annual review, or if it's having such an impact that it's causing such further difficulties for your child or young person, you can seek another annual review.
Thank you. A question for you, Kirsty. I think, at what age should we be thinking about applying for a health and welfare deputyship?
Well, I think what you should probably do is start thinking about it around the age of 15, because the process, or 15 and a half, because the process can take around the kind of the 6-month mark. It's definitely worth having a think about it around that issue of transition and speaking to social workers and really considering whether in the future it is something that you are going to be making several decisions about your loved one and therefore will need to be applying for it. It's not to say that it's appropriate for every family, but I think that's probably the age when you should start considering it and starting to talk about the professionals involved in your child's care to see if it might be appropriate.
Thank you. And talking about when an application has been made and rejected, we've had a question from somebody who's got an 18-year-old son who's got additional needs, and she's been unsuccessful with her application for health and welfare deputyship. What does this mean for making decisions for him if the deputyship hasn't been granted, and can the decision to refuse the deputyship, can that be appealed?
Yes, it can be appealed. People do that. I mean, the likely reason may well have been because the family perhaps didn't show in as much detail as what the court requires about all of the ways in which it's an over and above case compared to normal. Like I said, the court are very reluctant to make these applications. We do have some success with the ones that we've made, and I think the way that you do it is really by just putting in that additional evidence. You can appeal it yourself, and I would say put in some more evidence about the kinds of decisions that you will need to be making and why one-off decision making isn't appropriate for that person's needs. It is something that we can give some advice on as well, so we could review that application on their behalf and kind of give some advice about what we could maybe suggest if they did want to appeal it. In the interim period, it becomes the status that every time a decision is needing to be made on behalf of that young person, they would need to convene a best interest meeting with all professionals involved and the family, and it would need to be a joint decision, whereas when deputyship's in place, the person who has deputyship is the decision maker unless there are concerns about the way in which that decision has been made. So if they felt they had the support of the professionals in order to make the application, it may well be appropriate to try and appeal that.
Thank you. We've had another question here. Who is actually responsible for completing a continuing healthcare assessment? The person who asked the question has a daughter who is 17 and she hasn't had one.
Yeah, I can take that one. Yeah, so CHC funding is only appropriate where somebody has a primary health need. And so what I would say is that the initial checklist, which Rachel was talking about earlier, can be completed by a variety of health and social care practitioners. So it may well be that what you need to do is speak to the GP, or if you've got a social worker involved, or a case manager, someone like that, that would be your first port of call if you felt that it may well be appropriate. They will have vast experience in doing this, and so definitely if you feel that your daughter's conditions are primarily health related and would be eligible, then it's definitely worth having those conversations to see if that's appropriate.
Thank you. One for Rachel, I think. My daughter has physiotherapy in section G as well as section F. Would this continue for as long as the EHCP is in place? She turns 17 this year and we will be seeking education post the age of 19.
Okay, so we can never foresee what provision is going to remain in place for the lifetime of an EHCP. The purpose of an annual review is to identify what has worked well over the past 12 months for the child or young person and what additional support is needed for the next 12 months. So the answer is, unfortunately, we don't have a crystal ball, and we can't say that it will be there for the life of the plan. What we can say is that if it's in the plan at the moment, it will be reviewed at the time of the EHCP annual review. And if you have supported evidence to show that the physiotherapy needs to remain or needs to be increased, then submit that evidence as part of the annual review process to make sure that everybody involved has enough time to consider that. Get the physiotherapist to attend the annual review if you can, so that they can give oral evidence as well as part of that. So yeah.
Thank you. I'm conscious of time, but we can probably squeeze one more question in for you, Kirsty. What reasons would a deputyship be rejected?
So it may well be rejected if the capacity evidence isn't sufficient to show that individual lacks capacity. That might be the first thing. The second thing would be if the court didn't feel that it was appropriate for it to be made. And like I said previously, it could be that the evidence isn't sufficient to show that it's an over and above case in terms of actually granting that deputyship. It is a lot harder to get welfare deputyships, not at all impossible, and we've certainly supported a lot of families in order to get there. But we do show, we do know that the more evidence there is a lot more evidence you need to put forward in order to persuade the court that it is the appropriate thing to be made. So it may well be made on the fact that there's a lack of evidence from either side, really, in terms of that. Thank
you. Okay, I'm conscious of the time, so thank you everybody for taking the time to attend the webinar today. I hope you all found it helpful, and I just wanted to again thank our speakers today, Rachel Smurthwaite and Kirsty Stewart. As a reminder, the next session will take place next Monday at the same time, and we'll focus on planning for the future and why it is important. And we'll cover the importance of wills, what happens if you lose capacity during your lifetime, and powers of attorney. And over the coming weeks, we've also got more webinars coming up as part of the Bite Size series, which will deal with deputyships, welfare benefits and consent. So I hope you can join us for the upcoming webinars, and thank you again, everybody, for joining us today.